I'm Bernie McCloskey and I'm a solicitor in the commercial litigation team here at MKB Law. And I'm joined today by Managing Director Gordon McElroy to have a chat about the options available to a landlord to forfeit a lease.
As you know, I see this from the point of view of people letting property and sometimes for tenants taking property. Thankfully, I'm rarely on your side where things have gone wrong. So I'm talking to our clients about the good times when they're hoping to generate an income. But you see it whenever the tenants have stopped paying. So tell me, what do you do?
Yes, unfortunately, we're usually at that point in the proceedings when things have started to fall apart. But I think generally the first consideration for a landlord is to look at what the breach is, considering whether or not it is a breach of non-payment of rent, which is the usual situations that you have, or if it's a breach of one of the other covenants in the lease.
Okay, so let's take the non-payment of rent, because and we'll talk about breach of other covenants shortly, but non-payment of rent is the one that is probably the most common thing that we see. If I'm a landlord and somebody hasn't paid my rent, can I just go down and put a chain across the doors and have Mr. Muscles stand there and say you're not getting in until you have paid?
So the first thing you need to look at is the lease itself. So you need to check in the lease whether there is an express right to forfeit the lease for non-payment of rent.
Mm-hmm.
And you need to look at what the specific conditions are in that clause. So, for example, how long does the rent have to be overdue before you can exercise your right to forfeiture? So taking that point initially, and if you have a right to re-enter under your lease and if the rent has been outstanding for the stipulated period of time,
which is usually 21 days.
14 to 21 days, that's the usual period. At that point, you have the right to forfeit the lease by way of either peaceable re-entry, which is what you have just described, or by way of court proceedings. The peaceable re-entry option, there's certain considerations that the landlord must take into account when doing that. For example, there can be no use of excessive force. So that's something that you want to bear in mind in terms of whether or not the tenant is still in occupation of the property. If the tenant is not in occupation of the property.
So you can't lock a tenant in. You might be able to lock a tenant out, but you can't lock them in.
Not in. Yes. But if the tenant has already left the property, the risk to the landlord in that situation is really quite limited. If the tenant is still in occupation, there is the option to do what you suggested.
So why would I go to court?
The risk of exercising forfeiture by way of peaceful re-entry arises from the tenant's right to apply for relief from forfeiture. So in Northern Ireland, that is enshrined under the doctrine of equity, and it's also contained in the Judicature Act, which allows the tenant to apply to the court for relief from forfeiture if the tenant is able to show in the circumstances that relief should be granted and or that the forfeiture was incorrectly...
If my tenant or my client's tenant hasn't paid rent, why should they be entitled to relief from forfeiture?
Yes, so they're entitled to apply for relief from forfeiture if they are now in a position to pay the rent plus the costs plus the interest. The other matters the court will take into account is the conduct of the landlord. So, for example, whether or not appropriate demand was made for the rent, if that's applicable.
Do you have to demand rent?
It will depend on the terms of the lease. At common law, yes. But a common clause in most commercial leases nowadays is that the rent is due whether formally demanded or not. And in those situations, there's no need for a formal demand. But it's a point the tenant could raise as part of their equitable application. The court can take into account the conduct of both parties in the context of the forfeiture.
I have to say, I think it's unsafe to try to effect peaceable re-entry if you haven't demanded payment of the rent, irrespective of what the lease might say.
I think that's right. The main risk for the landlord is if it can be shown that the re-entry was inappropriate, the tenant could have a claim for damages against the landlord, which could include loss of business interruption, and depending on the business that your tenant is operating, you could foresee that those costs could be quite significant, particularly in light of the fact that if a tenant is then bringing an application for relief from forfeiture, that can take some time before it's heard by the court. And if the business is not operating during that period, there could be quite a significant claim against the landlord.
And of course, a demand in our language isn't necessarily the same as a demand in Mr. Mussel's language. So we need to be careful about what we mean.
Absolutely. And the advice in any litigation, regardless of the substance of the case, is that, you make that initial approach to the other side by way of a formal pre-action letter in any event. In the case of a non-payment of rent, that would look like a demand for the rent prior to taking any further action.
Okay. Let's say my client has a tenant who is paying the rent, but is allowing the premises to fall into disrepair, or is using them for what the Victorians nicely described as a noisome, noxious or offensive trade, such as tannery and some others which we won't mention on this podcast. What can I do about that?
Again, the first point of call is always the lease itself and whether or not that right to forfeit is there for a breach of any covenant of the lease.
Mm-hmm.
The matters for the consideration of the landlord in that situation will be whether or not the breach is capable of being remedied.
Mm-hmm.
If it is a breach that is capable of being remedied, there's an obligation on the landlord to serve notice under Section 14 of the Conveyancing Act 1881,
mm-hmm.
which is the legislation that still applies here in Northern Ireland, albeit it's been superseded in England.
We are very progressive.
We are. 1881 was a big year.
Yep. They were dancing in the streets of Dublin that night.
Absolutely. The provision in the Land Property Act in England and Wales is very similar to the procedure here. But essentially, the landlord must serve a notice on the tenant specifying the details of the breach. So using examples that you mentioned, the repair obligations, I think, is one that you would usually see this type of notice being issued. So the notice should specify the breach in sufficient detail that it can be remedied by the tenant.
Yeah.
It should set out a time period within which the tenant must remedy the breach.
Mm-hmm.
Usually 30 days would be a reasonable period, depending on how much work is involved in remedying the repairs, for example. That may also be stipulated in the lease, how long any such notice must be.
Yes, so you could have a period which says you must start the work within a certain length of time and finish it within a certain length of time.
Or confirm within a certain period of time that you agreed the works will be carried out.
Yeah.
And that's also an option. And then the last part of the notice must state that if it's not remedied, that you intend to exercise your right to forfeit the lease as a result of the breach.
Okay. And does that get you back to where you are with the non-payment of rent?
It does. It does. And essentially, once that time period has expired under that notice, your options are similar to non-payment of rent, which is either forfeiture by way of peaceful re-entry or the issue of court proceedings.
So very often when you have tenants who either don't pay their rent or they're in breach of covenant, it's because there's a more fundamental problem in their business, which has gone or is in danger of going belly up. And instead of dealing with the tenant himself, now you're dealing with a liquidator or an administrator. So can I go in and take possession of premises as against a liquidator?
Yes, the situation with a liquidator is similar to the situation as against the tenant directly. And oftentimes you find that actually the making of a winding up order against, if it's a tenant company, the making of the winding up order is actually grounds for breach of the lease and or forfeiture in and of itself, even if at that stage the tenant isn't in arrears of rent.
Mm-hmm.
As it could be you could foresee the situation that a tenant who is struggling financially may prioritise the payment of rent to keep their business premises, to keep the business alive as long as they can. But in any event, at that point, the appointment of a liquidator generally brings the lease to an end.
So, something that I've seen, it's a while since I've seen it, but has been a problem, has been where company goes into liquidation, the liquidator is appointed, and the landlord takes possession of the premises, puts the chain across the gates, and the liquidator says, but I'm entitled to get in there to get stock and equipment out so that I can sell it. What right does the liquidator have to insist on going in?
The situation after peaceable re-entry on behalf of the landlord is that where there is tenant property that remains in the premises, the landlord at that point becomes an involuntary bailee in respect of that property.
What's a bailee?
A bailee means that they are responsible for the property and owe a duty of care to the owner of the property to ensure that the damage, for example, is caused to the property. So in the situation where the tenant is not in liquidation, if we look at that in the first instance, the landlord will be under an obligation at that point to write to the tenant and give them the opportunity to attend that property and collect their goods, should they wish to do so, and put them on notice then at that point. If they don't collect the property, the landlord will take steps to sell it.
Faint recollection of something about the Torts Conversion of Goods Act.
Yes, that's exactly correct. The relevant notice comes under that legislation. So I think the same principle would apply where a liquidator has been appointed to the company. The landlord would be under an obligation to afford access to the liquidator to obtain goods and property owned by the tenant, which they can then sell and put towards the cost of the liquidation.
Right, so I understand what happens if a liquidator is appointed. Administration is a different thing because it's designed to preserve the business. So can I take possession if an administrator has been appointed?
No, the simple answer to that is no. So the moratorium will apply once the administration order.
The moratorium being?
That once a company enters into administration, there is no right on the part of the landlord to forfeit the lease either by peaceful re-entry or by way of court proceedings. The moratorium applies across the board against all court proceedings issued against that company. So no proceedings can be issued. Any proceedings that are currently ongoing are stayed. And can only be continued with either the consent...
Where a company goes into administration.
Where it's in administration. So the proceedings can only be continued with either the consent of the administrator or the leave of the court. So applying that to the landlord's right of forfeiture, the landlord can only forfeit with either the consent of the administrator or the leave of the court.
So I'm a landlord and I have a tenant whose business is in distress. Let's say they haven't paid me the last 3 months' rent and an administrator is appointed and the administrator says, well, I'm going to trade on from these premises. Does that mean that I don't get any rent for the future out of the premises?
No, if the premises are being used for the purposes of the administration, the rent continues to accrue during that period and becomes an expense of the administration.
Oh, so the administrator has to pay me?
He does. The other option in terms of the forfeiture, if that was the road that the landlord wanted to go down, an application can be made to the court for leave to forfeit the lease. And in that situation, the court will consider factors such as whether or not the forfeiture is likely to impede the purpose of the administration. So again, the administration process is different from the situation where a tenant is in liquidation because the overriding priority will be the continuation of the business, and that factors into what the court will decide in terms of forfeiture.
That sounds expensive and time consuming.
It is.
Yeah. Okay. Just a final point on forfeiture, Bernie. Can a landlord waive his right to forfeiture?
Yes, this is an important point for landlords to consider because it is quite easy to waive a right of forfeiture inadvertently, and particularly in cases where you're forfeiting for non-payment of rent. As one of the ways that the right of forfeiture can be waived is by the issue of a demand for rent or by chasing the rent. And you can easily foresee a situation where a landlord could inadvertently waive the right of forfeiture by perhaps dropping the tenant a quick email to say, just following up on the rent, can you let me know when it will be received? And something as simple as that can be deemed to be a waiver.
How do you prevent that happening?
You must immediately stop any communication with the tenant in respect of demanding the rent or chasing the rent, that isn't marked without prejudice, and conducted under careful consideration.
So this seems very counterintuitive, that a tenant hasn't paid his rent. The natural thing to do is to demand the payment of rent, because 9 times out of 10 you want the rent, not the premises back. But in order to get the premises back, the one thing you can't do is demand the rent.
Absolutely. It's catch-22. No, I think that factors into the decision that the landlord has to make at the outset of the case. If it's a situation that you think that the tenant is maybe having a difficult time in their business, but ultimately will be in a position to continue with the lease long term, you may take the decision to demand the rent and or issue debt proceedings in respect of the rent only, and not exercise the right of forfeiture. However, if the landlord considers that the situation has got to the point where the relationship is unlikely to continue, or that the rent is not going to be honoured in the long term, and they take the decision at that point to forfeit the lease in order to get the premises back, to perhaps re-let them, at that point, once that decision in respect to forfeiture has been made, and they have to be careful thereafter they don't inadvertently waive the right by demanding the rent.
Okay. I think I understand that, but once I've waived the right to forfeiture, have I waived it once and for all? So let's say the tenant misses the quarter's rent that was to fall due on the 1st of May, and I demand repayment of that. So I've waived my right of forfeiture. The tenant doesn't pay that rent, and then also doesn't pay the rent that was due to fall due on the 1st of August. And I say, I'm going to forfeit because of that rent, so I'm not going to demand it. Am I okay to exercise my right of forfeiture then?
You are in those particular circumstances, because your right of forfeiture
It's a new right of forfeiture.
It's a new right of forfeiture.
A new right has accrued.
That's correct. There's 2 types of breaches in terms of the right of forfeiture. The first being a once and for all breach that can relate to, for example, an assignment of the lease, which is prohibited.
Mm-hmm.
And
we haven't touched on that subject at all. That's for another day.
That would be for the next podcast. But the other types of breaches are what's known as continuing breaches. And as each time that breach occurs, a new right to forfeit accrues to the landlord.
Okay, that's brilliant, Bernie. Thank you for taking the time to explain it to me.
Okay, thanks so much.